discharging and consequently acquitting a citizen of all criminal allegations against him, and you proceed to appeal on that, or appeal against the judgment of the court. Why the person still detained? It hasn't happened. So we appeal against the order, stay execution of that judgment. The Supreme Court. We appeal against the order before the Supreme Court. On 2nd of November, the records on the appeal filed by the federal government was transmitted and served on the parties. It was served on the parties on this date. Now, by virtue of the fast track rules, parties direction 2013 of Supreme Court, which regulates this type of proceedings, the federal governments have only 10 days to file the appellate brief and serve on us. They didn't file anything, they didn't serve on us because the intention, which is obvious, is to use this process to further delay the release of Mazi and further keep him in perpetual custody, in solitary confinement at the custody of the SSS. Now, having waited for them to file their appellate brief before the Supreme Court, they will file. We now file our application, which anchor on 11 provisions of the law, asking the Supreme Court to dismiss the appeal filed by the federal government so that they can allow our client to go. That application was filed and served on the federal government on the 25th of November 2022. It was filed on the 25th of November 2022 and served on the federal government on that same day. Then, on the 5th day of December 2022, federal government filed their appellate brief. Instead of responding to this application, they filed the appellate brief. In this case, they secretly filed the appellate brief, hid the processes from us, despite the fact that at the point they filed this appellate brief, they entered into an undertaking with the registrar of the Supreme Court, and they will serve us those processes on the same day. They filed the appellate brief and also, along with the motion for extension of time, to regularize what they filed outside time. Then they filed them, they didn't serve us. They hid them from us. Now, we are following up because we have an application also we filed for accelerated hearing of the appeal, along with the application to dismiss the appeal. So, when we are following up on the response from the court as regards to these applications, and also the letters we are writing to CJ to assign the case to assign a date for hearing of their matter, it was brought to our attention that these people filed processes on the 5th of December 2022, and they didn't serve us. So, we now complained to the court, proceeded also to file application to obtain certified true copy of all they filed in court and hid from us. Then this, when we applied for that, the certified true copy of the processes they filed, it was immediately given to us upon payment of requisite official fees to the court. Then, when we received the processes they filed, we immediately filed our respondent brief. Then also served same on them on the 10th day of February 2023. Then, instead of them also reacting by filing a reply brief to what to file, they filed an application to amend their notice of appeal. This application was filed on 16th day, that is 6 days after we filed and serve on them our respondent brief. They filed the application to amend their notice of appeal by adding additional 9 grounds of appeal. They filed it on the 16th day of February 2023, and they didn't serve us. They still hid it from us. It was on the 2nd day of March when we are still following up by way of application, full application to CDM to assign a date in view of the medical condition of Nnamdi Kanu and nature of the case. That on this on account of that pressure, they served us this process they filed on 16th day of February 2023. They served them on us on the 2nd day of March 2023. So now, when this date was given, date for hearing of this appeal was given. Of course, when a date is being given or assigned to a matter, the courts will serve hearing notices to the parties, indicating that, notifying that the matter is coming up for subject for hearing. So, when the date was given and hearing notices were served on the parties, they quickly prepared an application for amendment of their grant of notice of appeal, same as the one they filed on the 10th of February 2023, and filed and served on us yesterday that was on 26th. This was 2 days ago. They served one at 2:39 p.m. Then served the second one on 6:30 p.m. They served on the office of our lead counsel, Professor Michael Zekome SN, in the night. So now it's important for me to clarify that the essence of what they are doing, these processes or their style, is nothing but to ensure that this matter didn't go on. You know, when an application to amend a ground of appeal is filed, then and the ground of you allow them, if it's granted by the court, you amend the ground of appeal, they will now file a fresh appellate brief. When they file a fresh appellate brief, you can now respond. They respond to what they filed. They will now file a reply. Of course, you know, Supreme Court is not a court that has all the time on earth to determine your matters. It's a court that gives longer dates. So what actually they are trying to do is that by filing these processes, the date will be given probably by next year to hear this appeal. But yesterday was the end of the game, because yesterday when we got to court, they mentioned all the applications, the frivolous application they filed, including the motion for amendment of grounds of appeal, and also the motion for amendment for extension of time to allow them come in. Now, the SAN said no, we are not objecting this time around, because we understand their game. Their game is for us to object. The Supreme Court will act of anger probably say, okay, come back on November this year, or come back on January next year, or March next year, for us to argue this application. So they're not objecting. That what we are interested actually is for the appeal to go on. Let's hear the case of the merit and let's be determined speedily, so that the effect of our client, Mazi, will be determined by the court. And court also found for us. Yesterday, the application for them to amend was granted. The grounds of appeal was granted. Now the court proceeded to give them timeline. We didn't wish to file their appellate brief and serve on us. And in this case, 5 days. The court gave them from yesterday to Wednesday morning to serve us. And from Wednesday morning, we have from Wednesday morning to Friday, Monday morning to serve them. We are coming back to court on Thursday to argue the appeal. So because what they wanted to achieve is, when we are in court yesterday, we mentioned the comment that we have an application to amend our grounds of appeal and also amend our extension of time for us to come in. And court will say, because we don't have the luxury of time to allow parties to be coming every day. No. So they will now, court will say, okay, we don't have the day this year. You can come back on January. But that doesn't work out for them. Then now we're going back to court on Thursday, 11th of May, 2023, to argue the appeal on the merit. Now, let me just clarify further. What has been making the headline in Nigerian media is that federal government filed additional grants, 9 grants of appeal against the leader of the people of Biafra. These are applications in substance that's frivolous, means nothing to us. Why? Because what they are actually asking the court to elongate, the grounds they are standing, is already contained in their appellate, in their 5 grounds of appeal, 5 which we challenge. It's contained there. These facts are contained in the original grounds of appeal they filed. They are the essence of what I do. What they want to achieve is to delay the proceeding, nothing more. Just to lift one sentence and say it's a grant of appeal, lift another sentence, the grant of appeal. So they will stand it, just like what happened in 2021 when Onyendo Nanikano was abducted in Kenya and brought to Nigeria. From 5 count charge, they expanded it to 7 count charge. From there to 10, from 10 to 15, and it's all over, all over Nigerian media. That the federal government has 5 amended 15 count charge against Nanikano. We want to escape this one. So the essence of it is to cause media hype. So that people will think they are doing something useful, or that they are serious about the matter. They are not serious about the matter. At the end of the day, we challenge the charge, and it was struck out. We go to one court of appeal, and the very same was also thrown away. So that will tell you they have nothing before the court against him. So it's not for us to make this clarification. So people don't think that there's anything serious about what they're saying. There is nothing serious about what they're saying. What they're telling what they want to amend is already before the court. We have it with us. They've argued this point in their original appellate brief they filed last year. We have it. We've argued it. I responded to them. So they're merely expanding it so that people will now say, oh, they have 100 grants of appeal against Nnamdi, and that probably will not come out on this one. This one is more, Nigerian mentality, and probably some misinformed elements who are being misled by their wrongs and misleading information. So it's better for us to clarify and tell our people that there's nothing, there's no problem. nothing to worry about. We are in perfect control, and also God is in control. So what they are trying to do in court, we are 10 steps ahead of them. We have already taken care of that. So let them come to court. Thank God that they have been now given time. They can't escape it. They are coming to court on 11th. Let us go there and appeal on the merits. Simple. So thank you. If they ask me further questions, I maybe have to give you further explanation. Thank you so much. Or if you don't, if there's any area I didn't it's not clear, I didn't make it clear to people to understand, I can also clarify because I'm talking to our people.
Ndewo Mazi, Barrister Ejiafo, for your clarifications and briefing. One thing you talked about this another, is it 11 ground or count ground for counts, other counts, 11 counts, and you have clarified it that it is not something new. What they are trying to do is media hyping, so that our leader will be condemned by the public. It's just like media trial now. But you've clarified it because that is what is going on the social media right now. That Mazi but thank God that you've clarified it. But now there is something that I want to ask also. You made mention of appeal or by the prosecution, and sometimes they don't inform you, the defending lawyers. They don't serve you any paper. What is that? What are the legalities concerning this? Is it legal for maybe the prosecution to do something, file a charge or another application, whereas they don't inform the defending lawyers? Is it legal under the Nigerian law or Nigerian constitution, please?
Thank you so much, Mr. Jonathan. Let me just take it count so people understand. First of all, let me correct you. Use the word expression count and the charge. There's no new count charge. There's no new charge against NK, against Oyenduma and Namikam before the court. What the amending is their grounds of appeal, which is just like somebody who is challenging the decision of the court. He's telling the court, the upper court or higher court, and challenging this decision on ground X, Y, Z, probably error in law and facts. And those grounds are just maybe issues of law and issues of fact. These are facts. So it's not charge, it's not count. So I have given you a clear detail here. See, look at what happened in court yesterday. What the legislature was trying to explain to the court yesterday. From the day one of this case, starting from the lower court before the federal high court, before the Sindaco's court, federal government has not been forthcoming. They have not been diligent in the prosecution of this case. What they wanted to achieve at every given point in time is for them to keep Nnamdi Kanu in detention. That's all. Now I will explain. When we are at federal high court, it has happened up to 5 good times. They will file it, they will amend the charge. A matter will be done for hearing or trial. Then obviously ostensibly in view of the fact, in view of the frivolous nature of the charge and post-screening nature of the charge, we usually challenge them. Then a date will be fixed for hearing of the charge application challenging the charge. A day before that day, they will, most times in the night, around 5, 6 o'clock, they will serve us amended charge. And as soon as they serve us those amended charge, they will make it available to the media before the court tomorrow. So by the time before you wake up in the morning, it's already being reported in the media. Federal government has them filed additional 7 count charge against Nnamdi Kanu. So it will not send fears to people. Are you with me? So it will not send fears to people that look, hey, Nnamdi Kanu will face something 10 count charge, something count charge. So it has been the practice. Or when we file an application, when we file an application challenging the competence of this fact, they will not respond. They will not respond most times. They will respond the day before the schedule for the hearing of the application. They will file their counter. And the essence of doing that is to truncate the proceedings of the court on the day scheduled for the hearing. truncating the process of recovery to frustrate, to stultify, and that's to stop the matter from going on. Because when you serve us with a response a response to application we file to get a process strike out, we are entitled to respond to that application to that response by way of reply. Now, and it's the law. We have to reply, because if we don't reply, then that means we are waiving our right to reply. And it will assume that issues you raise, new issues you raise in the application, your response, has been considered by us, have been waived by us, and admitted by us. So we are under an obligation to react by way of reply to the reply to your response application. So the usual serve us this stuff a day before the schedule for the hearing, and that was also called ambush. It has been their style. I give you an example now. Tell me what will cost a federal government, what will be responsible for a lawyer in a federal government, in a federal office, to file a process before the Supreme Court on the 5th day of December 2022. You file a process as important as respondent brief before the Supreme Court. And not, you didn't stop at that. You enter into an undertaking. You know what I mean by undertaking? Written undertaking before the decision of the court. That I hereby undertake to serve this process on the respondent counsel. You know, if you didn't sign that undertaking, they won't give you those process. So you have to enter as a lawyer, and you are signed as a lawyer, because they can't give those process a non-lawyer to sign, to enter on the thing to serve. No, you must be allowed to enter into undertaking before the decision of the Supreme Court, before they allow you to go and serve a process. Now you file a process on the 5th of December. Very important process as appellate brief, which you are challenging, upon which you have already filed application to get the appeal dismissed. You file this process on the 5th of December. And you hear it from us. After entering into undertaking, before the reach of the Supreme Court to serve us, they didn't serve us. Till yesterday, they've not served that process.
Mazi, before you continue, let me put it here as a question. Is there any legal backing for this type of ambush? Is there no law maintaining that there should be a frame of time, instead of waiting for maybe less than 24 hours and to start doing all this?
This was exactly what I discussed with some we discussed yesterday. There's a law regulating this proceeding. We call it Fast Track Rules 2013 or Supreme Court Fast Track Rules 2013. It's the line time within which to, because this appeal is so that can be heard speedily. It's appeal classified under this rule that among the appeal that can be heard day to day by the court, by the court. So, and there's a time within which to file this response, this application, the processes being conducted, being had under this proceeding. You are allowed to file this appellate brief latest 10 days after you compile records and serve on the parties. They didn't file. Now, it's been done without consequences. Ordinarily, if you ask for cost, like yesterday, we told the Supreme Court this matter has been in Supreme Court since October. They were shocked. We made it was said in open court by themselves that this appeal has been in this court since October. And they know the nature of the appeal. And they were concerned about the delay. And when it has to do with liberty of a citizen, and when it has to do with the threatening health condition of Mazi Nnamdi. So these are things they consider, because it's also by now, should have been had by now. So, and portion to which they give us this short date, 2 weeks from yesterday, to come back and argue the appeal. We understand that, you know, when you are battling with the system, it's an establishment we're fighting against. It's the government of the state. So that's what I do, whatever they want. If the government is not involved, I don't believe that a lawyer, an independent matter can be conducted in that manner. You will come to a Supreme Court, and file an application and enter into an undertaking to serve same on the parties, and went away with it without serving us the processes. Then you can come to back to that court to talk to the court. It's act of misconduct, professional misconduct on the part of the lawyer. It's serious act of misconduct for a lawyer to ambush another. It's an act of misconduct. So, however, because you know these are traps. What I want to tell the friends this night, that these are traps they set for us, and traps to ensure that there is a delay in this case. And when you understand this trap, you have to be careful and circumspect. Circumspect is saying that you have to align yourself with a position that will allow the appeal to go on quickly. Because if you want to challenge every of the steps, irregular steps they've taken so far, since this appeal was filed till date, that means this appeal will may not even be had this year. And who is suffering is a client. So we have to align ourselves, our position with a position, a process that allows that people to go on speedily. So, but not without mentioning this irregularity before the court yesterday. It was clearly marshaled out by the legislature as to how they transmit record and serve on the practice of 2nd of November 2022, and they didn't file processes appellate within time. They file and hit from us. Now they file a both amend their grants of appeal. They file it since February 16th, 16 February 2023. They didn't serve us on the 2nd of March. So what they are trying to do is just strategies to buy time. So this man will be there. They want to keep him there. And when this appeal is not had, it's not going anywhere. So, but luckily, God intervened yesterday. It was a very, very wonderful outing, because God saw with us that, look, there is actually a plan to delay this proceeding. They are doing it because they know that Supreme Court has no luxury of time to entertain cases, because the docket is full. So, but after explaining to the court about the nature of the case, of course, it's statutory, and the conduct of the prosecution in this case, of the appellate in this case, the court has to give us a shadow to hear the matter. Even the cross appeal I mentioned here, we cross appeal on some issues of law, which that has with the show of appeal. And they didn't respond till also late this year, they responded. They will file our response, our reply immediately. So that one has been settled. It was also mentioned to the Supreme Court yesterday that our cross appeal has been settled, because we filed the responded and we file our appeal, our reply. So it's adjourned till 11th of May. Once the same appeal is had, we can cover appeal can be taken together, because they have the same appeal number. So now that there's no penalty, that's penalty. Most cases, court will sanction you. Court will ask you to pay tax, to pay fine, right? And in some cases, you will be referred to NBA. So there are penalty and consequences for this kind of actions. But you know, when you are doing a case against establishment, which obviously have control over all other sectors, you have to be up and in. You must be circumspect. You must be careful and know when to act and when not to act, and know what step or decision to take at any given time. Thank you.
The woman say Barrister Jofo. And before I dive into another aspect, I want you to please clarify again the court judgment, appeal court judgment received on the 13th day of October 2022, discharging our leader, that he should not only that he should not stand any trial in any Nigerian court. Okay. Yes. Today the case is being taken up, applications on Supreme Court, which is the apex court in Nigeria, normally. Now, what I want to ask is this. Is there any law compelling that appeal court judgment should be respected first before any other Supreme Court or any other appeal or any other case? Is there or is it constitutional? It doesn't matter that it is against the establishment, but the establishment normally in a democracy, in a republic, the establishment must go through the rule of law. That is it. That is how it is all over the world. But what I'm asking is the Constitution. Does the Constitution allow somebody discharged by the appeal court, no matter the Supreme Court application or charges or anything again? Does the Constitution allow the person to continue being detained, or according to we talk to Biafrans, talk to the whole world according to the Nigerian Constitution, not according to how the establishments wants to do their thing? No. Does the Constitution mandate that court ruling should be obeyed first, or is there any way the Constitution allows the defendant to still be held pending the outcome of the Supreme Court issue? Please clarify that, please.
My brother, let me just explain this to you. You know, when I was doing the introductory part of this discussion, I expressed concerns about the fact that there are what are obtainable in the criminal jurisprudence and what are not obtainable in civil jurisprudence. And most times, what's obtainable in civil jurisprudence is not what's applicable to criminal jurisprudence. As a matter of fact, what I'm talking about is an appeal. It's a criminal matter, criminal appeal. The judgment of the Court of Appeal delivered on 13th of October 2022 is very clear in terms and unequivocal. And the law is that you must obey this judgment of the Court of Appeal and consequential orders made herein. And there is no even under the practice direction of Court of Appeal, or Court of Appeal practice direction, or under the Court of Criminal Appeal under the Court of Appeal does not allow for stay of execution of criminal appeal of criminal judgment on criminal matters. Doesn't allow it. Now these are issues we can pass before the Court of Appeal. But now let me just explain this. Conveniently or procedurally, a party have the right to challenge a decision made by lower court before the upper court, higher court, by way of appealing against that decision, and by extension applying for stay of execution. It's allowed under the civil appeal. Our contention is that this kind of decision is not allowed, but there's no rules that make provision for it under the civil appeal, under the criminal appeal. That's what I say, all the contended before the criminal appeal. So ordinarily, there's no rule that allow you to stay the liberty of a citizen. It's not hard, and it is more so that all the judgment of the court or the Supreme Court relied upon in moving the Court of Appeal to stay the execution are all civil cases. They are criminal matters. All the judgment decided before the Court of Appeal in granting that an application for stay are all civil cases, they are not criminal matters. So you see, these are irregularities we challenge in our motion to dispute the appeal, to dispute the other stay execution on our appeal. So there is no. So I don't want to delve much into the merits, into the substance of this issue, because of course it's matter before the Court of Appeal and Supreme Court. And as I speak now, of course everybody, including the DSS, the police, the military, the civil defense, the man of war, the public, everybody's listening to me as I speak to you, even the courts. So there are issues I may not delve into, but I have to kind of make a highlights as to what I want to understand. The fact that these are not done is not allowed under the law. I will have a file appeal against what they did in Court of Appeal by staying in the execution of judgment of Court of Appeal. That's the only option available to us. We can't fight them. And the appeal is before the Supreme Court. Now, the own appeal is now for hearing. And yesterday, the court made reference to the appeal. I said the appeal also will go along with the appeal, which is going to be held on the 11th of May. So let me not go deep into, because argument I'm going to prefer this evening will be part of argument that will be canvassed in court on the 11th of May, in moving the court to first of all dismiss the other and also allow our second appeal on that, and also in moving the court to dispute their own appeal. So I wouldn't want to canvass it extensively in this program because of the fact that all of them are listening to me. Because once you mention Ejiofor is coming to address the media, they will start talking about Ejiofor. They will now start talking about the court. They have to suspend everything they have to do to listen to me. It happened yesterday when I was giving an award somewhere. I was delivering a speech, and some people say I will not. Some people protest against it. At the end of that, deliver the speech. So let me not go into that. So the point is that let me not go into for May 11th, 2023. But I can assure their fans that God is on the throne, and God being so kind, God being with us, we are going to appeal. We are going to get this appeal dismissed. God be on our side, because Nnamdi Kanu has not committed no offense to the law and has been discharged by court, by order and judgment of court, superior court. So we are doing everything humanly possible within the limits of law and within the confines of law to give him the best representation. Thankfully, we have an erudite senior advocate of Nigeria, almost nobody who is leading us in this case. So to be assured that God we perform wonders in Supreme Court. God bless you. Thank you so much.
Well, finally, before you go, I want you to talk about the health of Mazi Nnamdi Kanu, who is your client and our Onyendu, our leader, the leader of the indigenous people of Biafra. We have heard many things, about tuberculosis outbreak in the where he's been illegally detained. Please start by telling us, when last did you see him, and how is all this his health? Please, people are listening. Please go on.
I was with him yesterday after the proceeding before the court. We spent some time together, and he was recently diagnosed of tinnitus, the ear issue. So I know the DSS medical department does not have the advanced medical equipment to address it. It's still on medication, and heartburn, of course, is I've made it to the problem that he has been having heartburn, and also depletion in potassium content. So these are issues he's having, but he still is strong in spirit. I'm strong in spirit that there must be light at the end of the day, at the end of the tunnel. So, but he's not good health wise. I've been saying it time without number because I own the word explanation and it's a duty, an obligation to tell them whatever my findings will be each time I visit him. So, and I don't come to the media to regret. I don't come to the world to tell the world what's not the truth. So I will tell you when it's better and when it's not better. But yesterday I was with him to brief him on what happened in court. So we had an extensive discussion on the matter before the court and what we're expecting to happen on May 11th. And a level of preparedness too. So, and what we're expecting to do by next week when they start us the relevant processes. So, and also we discussed about his health too. So he said he's still on medication about the tinnitus, most undergo surgery. So these are the complaints he led to me yesterday. So, and I better also that I made it known to the world by this platform. So that's all. So that he's soaring strong in spirit tenaciously, and we're believing God that the God will do His will, and I'm praying for him to be alive. He will come out there alive and strong. So God is with us. God is with him. Thank you.
There were. Thank you very much, Barrister Ejiofor, for this update. I don't know whether you have anything. You still have anything to say as your parting shot on this program. Because many people are really worried about our leaders' health. So please go on if you have anything to say.
The only thing I can tell their fans is to be strong, remain focused. They should not be distracted because a lot are going on. Of course, what I want to also repeat at this point in time is that many people, when you see this kind of thing going on, you see a lot of people who are working against the interests of Mazi Nnamdi Kanu, either by actions or by deeds or by conduct. So, but let them remain focused and also obey the instruction from the central body. So that's where I can tell them, possibly not to be distracted because a lot are going on. Of course, you can know. I want to appreciate that we have changed our strategy. It's something that informed it because I discovered that there's a lot of things are not working properly the way it's supposed to work. And once you're able to identify your enemies, you have to treat them as such and place them where they belong and make sure that you work hard and progress. So what I'm telling our people is to remain focused, be prayerful, be abide. These are things you usually tell me. Remain be peaceful in their conduct. That at the end of the day, the truth will prevail and we'll be freed. And God will make it happen sooner than expected. Thank you so much, and God bless you all.
There were Barrister Ejiofor. Thank you very much, our erudite lead counsel. We understand that you are at the front line, bearing the brunt of everything. But we must continue.
Thank you so much, and God bless.
There were. Thank you very much. So much. I think this is where I'm going to leave you. Thank you. This is where I'm going to leave you.
Thank you, Mr. Jonathan. God bless you. God bless everybody. I appreciate you. Thank you for having me in your program.
Thank you.
God bless. God bless Biafra.
There
Thank
were.
you.
There were. And you too. Thank you very much.
Thank you so much.
There were.
Bye-bye, my brother.
Thank you. This is where I'm going to let go. Biafrans, you have listened, so every other thing we continue pushing on, because this is a process. Thank you for listening. From me, Mars Jonathan, from here, it is simply good evening.
Now, I want you to talk briefly about how the media